Hello, everyone. You're welcome to the last session of our African Arbitration Day. And it's my pleasure today to introduce the chairman and moderator of the session, Dr. Remy Gerbay. Remy Gerbay is a lecturer in international arbitration at the School of International Arbitration, Queen Mary, University of London. Where he is the co-director of the Distant Learning LLM Postgraduate Diploma and Certificate in International Dispute Resolution. Remy is a partner at US-based dispute firm Monroe Lankem, where he represents parties in international arbitrations and related litigation. He's admitted as an attorney in New York and DC, and as a solicitor in England and Wales. Remy sits frequently as an arbitrator and has been appointed in over 20 arbitrations under various rules: ICC, LCRA, Swiss Chamber, DIAC, KIAC, not just as co-arbitrator, but sometimes as sole arbitrator or chairperson. He holds a PhD in international arbitration from Queen Mary, an LLM from Georgetown Law, where he was a Fulbright scholar and had a Dean's Honors List. He holds a master's degree from Graduate Institute, University of Geneva, and French law degree from University of Lyon, where he made high honors. He's taught in various schools, and he has been the former deputy registrar at the LCIA, acting registrar at the DIFC-CIA in Dubai, and he has been identified as a future leader and who is who in international arbitration. Distinguished ladies and gentlemen, I hand you over to our moderator, Dr. Remy Gerbay. Thank you.
Thank you, Professor. Good morning, good afternoon, and good evening, everyone, depending on where you are connecting from. It is my pleasure to welcome you to panel 4, the final panel of this inaugural Africa Arbitration Day. I have the pleasure of chairing this panel, the topic of which is, a reminder, African courts and the enforcement of arbitral awards. Now, I've had the pleasure of being involved in arbitrations in sub-Saharan Africa over the years, but the true experts are undoubtedly our 3 speakers today: Sir McKenzie, Justice Abba Patel SC, and Tunde Ogunseitan, who I really look forward to introducing to you in just a moment. Now, this panel 4 will be structured in 2 parts, just like I think panel 3 was. In the first part of this panel, we will have short presentations by our 3 speakers who are going to talk about this topic of the role of the courts and the enforcement of arbitral awards, each time picking a number of subtopics and discussing them from the point of view of various jurisdictions, including in particular the jurisdictions that they come from, but not only. And in the second part of this panel, we will have a Q&A session. So we'll take questions from the floor, and we very much invite you and encourage you to submit your questions in writing using the chat function, as you might have done in previous panels. We very much look forward to giving you an opportunity to ask questions directly to the speaker. That's an important part of this panel. So without further ado, I'm going to introduce our first speaker, Sarah McKenzie. Sarah is a dispute resolution partner at the law firm Weber Wentzel in Johannesburg, South Africa. She specializes in complex, high-value litigation and arbitration, both commercial arbitration and treaty arbitration. She has represented parties in many domestic and international arbitrations under the rules of all of the leading arbitration institutions, including, for example, the ICC, but also African arbitrations like AFSA, the South African arbitral institution, the Chinese Arbitration Association, and also in ad hoc arbitration proceedings under the UNCITRAL arbitration rules or otherwise. She's appeared before various courts in the South African court system, including, for example, the Constitutional Court, the Supreme Court of Appeal, and various divisions of the High Court of South Africa. And of particular relevance to this panel today is the fact that she spent in a previous life a year clerking at the Constitutional Court of the Republic of South Africa, clerking for the Chief Justice, if I remember correctly. So Sarah, we should have a map that might be uploaded if at all possible. If not, we'll look at the map in a second. But I'll start with a question that is deliberately controversial, and I'm going to ask you, you're from South Africa, but are you able to give us the pulse of award enforcement in Africa in general, since this is the topic of this panel, if that's even possible? What are some of the local challenges that outsiders may associate, rightly or wrongly, with enforcing arbitral awards in Africa?
Thank you, Remy. I should say at the outset that Africa is, of course, a continent that cannot be seen as having a single set of challenges. Sorry to dodge your question somewhat. While the enforcement of international arbitral awards in Africa is considered complicated and difficult, the reality is, in fact, I think, far more nuanced than is generally thought. In this regard, the vast majority of the 54 African states are party to the New York Convention or to other multilateral treaties that facilitate the enforcement of awards. And I draw your attention to the graphic that we've prepared, which illustrates which African states are parties to the New York Convention. As you'll see, this is in excess of 70% of the states on the continent, with one or two notable exceptions, certainly a passing grade. It is true that there is a minority of African states that has adopted the Untitled model law, but there does seem to be an uptake in this, which we hope will continue. In practice, however, there appear to be varying degrees of willingness among state courts in Africa to enforce arbitral awards. There are, of course, some jurisdictions where enforcement can be challenging, but there are also some good examples. The variance is informed by the unique challenges faced by each state, both practical and political, and the significant diversity of legal traditions within the continent, including legal systems such as French, English, and Portuguese law, with some jurisdictions also influenced by Sharia law. South Africa, my home and the jurisdiction I'm of course most familiar with, provides a good example of reliable enforcement on the continent. The South African courts have consistently recognized and enforced arbitration awards, and this position should only be strengthened by our new International Arbitration Act, which came into force in December 2017. The Act creates a modernized arbitration framework which will work in tandem with South Africa's already efficient, effective, and impartial judicial system. Together with giving effect to the New York Convention and incorporating the Untitled model law, the Act provides the legal framework for the conduct of international commercial arbitration proceedings in South Africa. It applies to any international commercial dispute, which is a widely framed category in the Act, that the parties have agreed to submit to arbitration under an arbitration agreement. I'll add in passing that the South African legislature is also currently considering a revision to our Domestic Arbitration Act, which we and other stakeholders in the jurisdiction have been considering and commenting on recently. Under the International Arbitration Act, a dispute will not be capable of determination by arbitration if it is not possible to refer the subject matter of the dispute to arbitration under South African law, or where this would be contrary to the public policy of South Africa. It's really matters of status and matrimonial issues that are precluded under the Domestic Arbitration Law, and that would apply equally under the International Arbitration Act. Under the Act, an arbitration agreement and a foreign arbitral award must be recognized and enforced in South Africa, and an arbitral award will be recognized as binding and on application in writing to a competent court will be enforced subject to various exceptions in a schedule to the Act, which are based on the model law exceptions. South Africa's accession to the New York Convention was not made subject to the reciprocity or any other reservation. So we think it's safe to say that South Africa will effectively enforce arbitral awards emanating from any jurisdiction. Unopposed enforcement proceedings in South Africa generally take 2 to 3 months from the date of filing the application, and I'll put a caveat there that this may be affected by COVID. We yet to really see the impact on enforcement proceedings, obviously in the absence of urgency. Opposed proceedings take a little longer. The length of delay in opposed proceedings depends on the division of the High Court in which the enforcement proceedings are instituted. but we'd estimate around 7 to 8 months, again in the absence of urgency. The South African courts have historically exercised significant restraint when considering the application of this, the public policy exception and the other exceptions in the Act and in our common law. In order to give you a sense of the attitude adopted by the South African courts, I think it's helpful for me to highlight some indicative examples. In the matter of Telcordia Technologies versus Telkom, a dispute arose as to Telcordia's delivery obligations of certain highly specialized software under an agreement which hinged on the parties' respective interpretations of the agreement. The dispute was referred to arbitration administered by the ICC, and the arbitrator ultimately accepted Telcordia's interpretation of the agreement. Telkom then proceeded to launch an application in the High Court in South Africa for a review and setting aside of the arbitrator's award on the grounds that in incorrectly interpreting the agreement, the arbitrator had committed a material error so fundamental that he had misconceived the nature of the inquiry and his duties. And secondly, that by denying Telkom the opportunity to apply to court for an order compelling him to state legal questions for the decision by the court, the arbitrator had committed a gross irregularity and acted irrationally. Although the court upheld the application on the latter ground and reviewed and set aside the arbitrator's award, the South African Supreme Court of Appeal upheld an appeal by Telcordia against this order and set the order of the High Court aside. In doing so, the Supreme Court of Appeal emphasized that an arbitrator is always entitled to be wrong on the merits, and a wrong interpretation of the agreement did not amount to a misconception of the nature of the inquiry and therefore to an irregularity, and that a wrong interpretation of the agreement also did not entail the arbitrator exceeding his powers. The ruling resulted in a significant award of approximately 1.5 billion South African rand against Telkom being upheld. And because Telkom is a state-owned entity, I think this case usefully illustrates the South African court's readiness to uphold arbitral awards even when a significant quantum against state bodies will flow therefrom. In the case of Balkan Energy Limited and another versus Government of the Republic of Ghana, an ex parte application flowing from an award in an arbitration administered by the Permanent Court of Arbitration to attach shares held by the government in Ghana in Anglo Gold Ashanti, which was registered and incorporated in South Africa, was brought in the South African High Court in 2017. The dispute between the parties had its origins in a power purchase agreement that was entered into by the parties. In terms of this agreement, the respondent, the government of Ghana, had leased and contracted the second applicant in Ghana to operate a dual-fired diesel and gas power barge on its behalf for the purpose of generating and supplying electricity. The dispute that arose between the parties gave rise to an arbitration held in London during 2013, and in April 2014, an arbitral award was made against the respondent for the payment of various amounts as well as interest on some of those amounts. The litigants cited in the proceedings were all foreigners from the South African court's perspective. The only connection to the forum of the court in South Africa was the fact that the respondent owned shares in a company with its registered office situated within the jurisdiction of the court. The court concluded that the applicants were entitled to the relief that they sought, and the sheriff of the court was authorized and directed to attach the shares of the respondent in South Africa. And I think this case is also helpful because it illustrates the willingness of the South African courts to enforce arbitral awards even against foreign governments in South Africa. In spite of South Africa's very strong track record, I will concede that we are not without incident. And in a recent and controversial judgment, the High Court of South Africa set aside an attachment authorizing the attachment of an aircraft owned by the Tanzanian government in satisfaction of a foreign arbitral award on the ground that the award ceased to exist when it was converted into an order of the courts of the seats in Tanzania. There are, however, many examples of the South African courts taking a robust approach to the enforcement of international and domestic arbitral awards, and in my view, this is a very good example of reliable enforcement on the continent, informed, I think, by a very sophisticated local legal fraternity and a judiciary well-versed in the arbitration landscape. It is true that some jurisdictions on the continent have some challenges to overcome, but there are some success stories in Africa that should be celebrated. Thank you.
Thanks a lot, Sarah. A lot of interesting points, which I'm sure we'll be able to pick up in phase 2 of this panel when we have questions from the audience and we discuss these questions. So moving on up north a little bit from South Africa into the high plateau of Zambia, our next speaker is Justice Abba Patel SC. Justice Patel is the judge in charge of the commercial division at the Kitwe High Court in Zambia. And in that capacity, she hears a wide range of commercial cases from corporate insolvencies and business rescues to appointment of receivers and liquidators, bank debt and foreclosure actions, and of course, breach of contract. Now, in addition to that, applications for the registration and setting aside of arbitral awards and for urgent interim relief applications in support of arbitration also fall, as I understand it, within the remit of the commercial courts, the commercial divisions of the high courts in Zambia. Now, prior to her appointment as a judge in March 2019, Justice Patel had a career spanning 30 years as a counsel, and in particular, she became state counsel in 2016, making her, at the time, only the third female advocate to achieve this level of recognition in Zambia, which is quite something. Justice Abha Patel SC read law at the University of Zambia and at Cambridge University in England. She is admitted to the Zambia bar since 1989, but also to the role of a Solicitors of England and Wales since 2008. She is also a qualified mediator and arbitrator. She's a fellow of the Chartered Institute of Arbitrators, for whom she conducts a lot of training in international arbitration, which is a point that I'm sure we'll have an opportunity to discuss very soon. So, Abba, if I may, I understand you're not going to discuss just Zambia, but you're also going to talk to us about another jurisdiction, Ghana. And so one of the things that I'm sure a lot of people will want to hear us talk about is public policy. It's of course a hot topic when it comes to the enforcement of arbitral awards. I guess not least because public policy is of course one of the grounds for under Article 5 of the New York Convention for refusing recognition and enforcement of a foreign arbitral award. And a related topic to public policy is how can we foster uniformity across countries in the interpretation of public policy. We know that often what constitutes public policy in one place may not quite look the same in another jurisdiction. And so what can be done working with the judiciary, working with judges to try to improve the situation of enforcement. So these are some of the themes, Abba, that I'd love to hear you talk about, but the floor is yours now.
Thank you. Good day, everyone. And Remy, thank you for that introduction. You put a smile on my face, reminding me of all the things I've done many, many years ago. It is indeed a pleasure to be here with you all, and I will echo the comments by Professor Mohammed and commend the organizers for this wonderful conference in what is now becoming the normal way of interacting and sharing ideas on such a platform. Through Professor Bankole, I thank the organizers for inviting me to be a part of this very stimulating conference. As a panel, Remy, if I can go straight into it, we have realized how vast the subject is. In fact, it's almost as vast as the African continent and the 54 countries that make up the continent, each with its own domestic regime, laws, languages, and cultural practices. Put them all together and you get this huge calabash and a pot called Africa. And we try as hard as we can in 2-day seminars like this to try and solve all the problems of Africa. But over the years, and I believe in this conference also, we have heard much and debated the role of Africa, the increase in foreign trade, especially in the extractive industries, such as oil, gas, mining, and infrastructure, projects such as roads. Obviously, we have debated the disputes have arisen, will continue to arise, and we note that these are significant high-value disputes. We have talked about various arbitral institutions across the continent, and I think the panel before us also talked about some of these, some of the key institutions. And having seen the map that Sarah referred to earlier, we can perhaps begin to appreciate the magnitude and the enormity of the problems that surround the African continent. I'm going to speak to you very briefly about enforcement of foreign arbitral awards, the time obviously being the only limiting factor in a debate of this magnitude. I consider myself, however, Remy, to be in a privileged position sharing my personal experiences with you all from the position of being a practicing attorney and arbitrator to being what I call a baby judge, having been appointed to the bench only 18 months ago. And of course, now looking at the same issues, but from the other perspective and from the other side of the coin. We all know and we appreciate the backbone of mutual enforcement of foreign arbitral awards rests on the New York Convention, which mandates a signatory country to enforce an award granted in another signatory state. And we've also heard about this from the earlier panel today. In looking at the enforcement regime under the New York Convention, I'm going to look at two particular jurisdictions. I want to talk very briefly about Ghana, and of course, I will then talk about my home jurisdiction, Zambia. Ghana, as we know, is a signatory to the New York Convention, which has directly been incorporated into its laws. I think Sarah showed us this through the map that we earlier referred to. The practice has been that the Ghanaian courts are by and large willing to enforce awards and do not interfere with enforcement unless one of the grounds set out under Section 59 of the Act, which is the Alternative Dispute Resolution Act of 2010, has been raised. These grounds, for those of us who are interested, are quite normal. They are the usual ones: that the award has not become binding on the parties, the losing party was not given sufficient notice, and all the others. The ninth ground is something that I would like to talk about, and Remy, you talked about this in your introduction. It talks about recognition and enforcement would be contrary to the public policy of Ghana. And of course, the procedure for enforcement is fairly straightforward. The application must be on notice to the losing party, requires the filing of motion papers, supporting affidavits, the original agreements, and the affidavit in support. The court does not examine the merits of the award, and I think we are all on the same ground when we talk about this, that most of the African jurisdictions have taken that on board, that the role of the court is not to examine the merits of the award, except to satisfy itself that the award was made in accordance with Section 59(1) in the Ghanaian context, and that the award was made by a competent authority, and that there is a reciprocal arrangement. Obviously, once leave is granted, the award may be enforced, and an execution can levy in the normal manner, like it would with all other court processes. It is noteworthy that foreign arbitral awards and enforcing foreign arbitral awards is perceived to be straightforward, and I say perceived to be straightforward. And there is a time limit of 6 years for foreign awards. The courts in Ghana are seen to be pro-arbitration and do not easily set aside arbitration awards, even where the application for enforcement is opposed on grounds of public policy. So what am I saying here? There are pitfalls whereby enforcement of a foreign arbitration award may be challenging. Section 1 of the Act excludes matters relating to national or public interest. What do we mean by that? The environment, the Constitution, and the general, and I believe the umbrella clause, any other matter that by law cannot be resolved by an ADR method. And obviously, if the dispute falls within these 4 areas, enforcement of such an award is deemed to be problematic. It is interesting, and I think we'll all agree with this, that the term public interest has not been defined by the Ghanaian Act. And it will be of interest perhaps in the Q&A session for us to share experiences under this general concept of public interest, and I use that in inverted commas, commonly employed by African nations. The term, of course, as has been submitted by some people, leaves room for varied judicial interpretation, leading to uncertainty and perhaps over judicial vigilance and over active judicial vigilance. We can talk about this, but let me park this issue here for the moment and move on. I know we talked, I think Sarah talked about one of the cases where the award was enforced in South Africa. But to the best of my research, I note that the Balkan Award was not enforced in Ghana. And I would believe this is a clearly calculated risk, being mindful of the potential pitfalls in deciding whether to take the award to Ghana for enforcement. Now, we need to look at what can African countries do to inspire confidence around issues of enforcement. And I'll leave this to the general debate, especially where the state is a party. And this is perhaps the overriding aspect of what do we do when an African state is a party to the dispute. Commentators, however, have cited Ghana as an attractive venue for the enforcement of foreign arbitral awards, and the judiciary is reportedly proactive in upholding arbitration awards. Let me move away from Ghana, Remy, if I may, and talk briefly about the strides that we have made in Zambia, which is my jurisdiction, and which I have been in the forefront of the ADR movement, firstly as a practitioner, at which time I did receive most of my training in arbitration and mediation. And as I said, now being a judge, especially being a judge in the commercial division. Zambia passed its new Arbitration Act number 19 of 2000, which repealed and replaced the previous Arbitration Act. Zambia, as we know and as we have noted, is a signatory to the New York Convention and has embodied the model law within its law. The new act did not only repeal and replace the old law, but did adopt with modifications the model law. And the preamble to the act actually reads that the purpose of the Arbitration Act, and I quote, is to redefine the supervisory role of the courts in the arbitral process. Section 10 of the Zambian Arbitration Act empowers a court upon application to stay proceedings and refer the dispute to arbitration. The courts are obliged to obey parties' choice in the dispute resolution process. Remy, I feel it's important for us to appreciate that in recent years, the Zambian judiciary has drawn a lot of its judges from senior members of the bar, several of those who have had prior knowledge of and have been in the forefront, the agitators, if you like, of the ADR movement in Zambia. These judges trained in ADR, and I will confine my comments more specifically to arbitration, are and have continued to settle the jurisprudence of the law emanating from challenges to the arbitral process, be it at the point of challenge to jurisdiction, the appointment stage, or indeed at the point of registration and enforcement of the award. Our apex court, the Supreme Court, constitutes a bench of which several judges have the specialized knowledge and skill set. And it is no surprise then that these judges usually form the panel that hears appeals arising out of high value arbitral proceedings and those that obviously reach the Supreme Court. The rising number of decided cases reveals the inclination of judges to rule in favor of the arbitration clauses as embodied in the various contracts, despite challenges to them of being inoperative or incapable of being performed. And the attitude of the Zambian courts has been in adopting a liberal approach in judicial reasoning and leaning on the intention of the parties. One of our celebrated cases that might be of interest is the case of China Henan and International Corporation versus G&G Nationwide Limited. This is a selected judgment of 2017. So it's a very recent judgment. This dispute obviously found its way to the Supreme Court, comprised of a panel of 3 very seasoned arbitrators who were all, by the way, previously judges in the commercial division. The Supreme Court seized the opportunity and really sent the message home. It sent the message home to the judges in the trial courts. It sent the message home that the courts would not encourage and would not allow judges to interfere or to actually come into the arena of the arbitral process, so to speak. The Supreme Court went further and delimited the powers of the court over arbitration proceedings, and made sure that the trial courts understood that they were not an appellate body charged with reviewing decisions of arbitral bodies. It is important also to note that the Supreme Court held that not even the High Court, which under the Constitution allows unlimited jurisdiction, has any unlimited powers over arbitration. They reaffirmed, obviously, the competence principle. And this decision is being hailed by arbitrators and jurists alike that it has set a very high tone for entrenching arbitration in Zambia. Section 17 of our Arbitration Act obviously sets out grounds to use in setting aside an award. And of course, we need to talk about the fact that the issue of public policy does raise its head and has raised its head in Zambia. In my research for this paper, one of the cases that I came across was a judgment delivered by my judicial brother in the case of Mupulungu Harbour Management versus the Attorney General and Mupulungu Harbour Corporation Limited, where the much touted issue of public policy was examined at length. The court in that case set aside the award, but sent it back to arbitration, citing as its reason, as one of its reasons being the issue of public policy and the perception of bias. The court used extensively a decision of the Supreme Court of Zimbabwe in the case of Zimbabwe Electricity Authority. Again, it's something we can talk about. But other than that, I think the grounds for resisting enforcement are fairly straight in Zambia. The statute is clear, and there rests the law. But we heard this morning from the keynote speaker, from Honorable Mike Chibita, of the philosophy and the judicial reasoning employed by the courts in Africa. It was interesting, and I heard him say that arbitration will continue to play second fiddle to court judgments. I don't actually know whether we want to talk about that, because obviously Justice Chibita was expressing an opinion, and I would like to take the view that in Zambia we are now speaking, I believe as a judge, that we are not asking the courts to play second fiddle or first fiddle. We're simply saying arbitration is a standalone process, and it should be given the respect, and it should be given the place that it deserves on the different manners in which matters are taken before various tribunals, be it an arbitral tribunal or be it a different matter that comes towards the national courts. I haven't actually in my research, and I hate to say this, come across any foreign arbitral award that has been registered or opposed in Zambia, but I have come across a new matter which I believe has been registered under the ICSID laws, ICSID process, which I believe has only recently, the arbitral tribunal has taken conduct, and I believe it was only as recently as 18th August where the president has taken conduct. Needless to say that I and perhaps others will follow this with keen interest, because one of the parties obviously is the government of the Republic of Zambia. So we need to see where this matter ends up, and I believe this is a common concern running throughout this conference. I don't know if I have any more time, or shall I leave it at this stage, because we can always talk in Q&A about what the courts are doing and what we need to do about giving the support to the courts, and I will obviously now speak to that if I'm given a further opportunity. But I will leave it here, Remy. Thank you very much.
Thank you, Abba. Again, a good number of very interesting points that we will address, no doubt, in the Q&A session. So we're going to move up north again. Our final speaker is Tunde Ogunseitan. In fact, we're moving so much up north that we're back in London. Although I understand that Tunde might possibly be flying the flag of Nigeria today. No pressure. And so
it's the only flag I fly, actually, Remy.
It's the only one you fly. Okay, good. We might have a map, I think, which could potentially be uploaded now if we can. So Tunde is an international dispute resolution lawyer based in London with extensive experience of dispute resolution. He will be well known to many of you as the former ICC counsel in charge of the common law team at the ICC Secretariat, a position, here we have the map, a position which he occupied for over 7 years before returning to private practice very recently. At the ICC, Tunde was instrumental in the institution's recent push to increase the organization's dialogue with the African market. And prior to his time at the ICC Secretariat, Tunde was in private practice with international law firms, US international law firms, including Steptoe and Johnson and Cadwaladr. Tunde teaches ADR and international arbitration with our friends at SOAS in London, but also at the Catholic University of Lyon, near where I come from. He is a court member of the Lagos Court of Arbitration, and he currently chairs its committee on reviewing the Lagos Court of Arbitration rules. Like Justice Patel, Tunde is also a fellow of the Chartered Institute of Arbitrators, and he intervenes in as part of the teaching faculty of CARB, training individuals in international arbitration. So Tunde, I was going to ask you as a first question, based on your background, what institutions can do to minimize the risk of non-enforcement. But seeing that we have the map here, do you want to tell us it's not actually the map that I had in mind. This is the map of...
that's the other map.
That's the other map. Okay, so when we get the map that you submitted, we'll get back to it. So let me revert to the original question. So as a former ICC counsel, and I understand you're speaking on in your own name now, what can arbitral institutions do to help minimize the risk of non-enforcement on the African continent?
Thank you very much, Remy. And I would also like to thank the organizers for inviting us to speak today. Also, I'd like to thank the attendees for taking time out of their busy schedule to come and listen to us today, because it is always a privilege to speak at one of these things. The three topics I am going to discuss today are what can arbitral institutions do, as Remy suggested, but also what the cultural differences are in the implementation of awards or enforcement awards, rather, sorry, on the African continent. The first thing we have to say is something Sarah has touched on and Abba has touched on, is that Africa is too big a place. And I think the map I was going to put up was going to highlight that. And that map, just by looking at it, will have told you how many different jurisdictions you could fit on the African continent, and how we don't expect those jurisdictions to be taken as a whole. And if we think of how many legal cultures are in those jurisdictions, I mean, for example, we can see China, the whole of the US, Eastern Europe, India, the UK, and all the other European jurisdictions, which have unique arbitration jurisdictions. The good thing is that they also influence the legal cultures on the continent. We have Arabic, we have, the civil system, the common law system, and also all interplaying. Some of them have two. Places like Cameroon and Rwanda are bijuridical. So it's quite hard to pinpoint the cultural differences because they're vast. To go back to the question Remy asked me, what can the institutions in Africa do to ensure? I think they're already doing it. Most institutions in Africa follow loosely other institutional rules like the ICC, the LCIA, SIAC. And most of those have, over the years, improved how they administer arbitrations. The problematic areas you see usually are in the beginning of the arbitration, the appointment of arbitrators, when, for example, state entities don't appoint their arbitrators. And you see that institutions generally take a very considered approach to ensure that if a state entity, for example, is not participating, the arbitrators that they appoint on behalf of those state entities are beyond reproach. They have no disclosures that would otherwise disclose them. I know Abba will be nodding her head because we've had an experience while I was at the ICC when this happened. But institutions are taking a more conservative approach. Also in For example, making sure that the right entities are litigating. What most people will try and do is extend their arbitration agreements. And here I think it's important that we make a distinction between state entities and states. Parties who usually contract with state entities will ultimately try and drag the state into the arbitration because they believe that the state entities, even if they hold a minuscule percentage of the company that is involved in the dispute, it's better if you have a state on the hook, because more than likely enforcement will be easier come later, i.e. you can look for assets globally to enforce against with a state, but with a company, usually those assets are limited to the jurisdiction. Now, what arbitral institutions are doing carefully is ensuring that the right individuals are being sued and or joined in the arbitration when it's going on. The joinder requirements for the ICC is so stringent. For example, in 6.2, 6.3, 6.4 decisions that have been made. When I say that, that's Article 6.3 and 6.4. And Rwanda runs the same rules. I believe LCA also runs the same rules, and Cairo also runs the same rules, at least in a similar form. What the amount of exercises that go on internally to ensure, at least on a prima facie basis, that this entities can be joined is quite serious. Another one that has come to light as to what institutions do is, for example, how they deal with challenges. That happened recently in Nigeria with Global versus Shell, and another instance where an award has not been enforced properly, has not been enforced at all, and has been annulled, in fact. Interestingly, if you look at statistics in challenges, the things that are taken very seriously at the institution. Let me take the ICC statistics, for example. In 2018, there were 45 challenges and 7 were accepted. In 2019, there were 52 challenges and 6 were accepted. If you want a reason as to why your challenge wasn't accepted, you can ask for it. Institutions are more transparent than they used to be. For most things, if you request ahead of time, you can get reasons from most institutions, I believe nowadays. So institutions are doing things on the procedural side to ensure that the awards are more acceptable to the courts when they do appear to the courts. But the question is, why are awards not being enforced? Or why is there a perception that awards are not being enforced? Again, this is only a perception because we have to differentiate the commercial cases from the investment cases. And at least from my experience, most commercial awards are actually paid off. Even the ones with the states, they're paid off quietly. And how do I know this? If they weren't paid off or there was a delay, and there are delays in cases like IPCO, we would hear about it. But these don't form the bulk of arbitrations that you have in Africa. The ones we hear about are the aberrations. And it's these aberrations that concern us, that create a perception that international awards are not being enforced in African jurisdictions. They might take time, as EK said, as Paula said, but they're mostly right. And when you say they might take time, the case that comes to mind is IPCO versus NNPC, which is, I believe, a still running saga. But the cases you also get, like GETMA, the cases like Global versus Shell, you get in various jurisdictions, are aberrations. If I take the Nigerian jurisdiction, for example, in a case that created outrage, Global versus Shell recently, I'm not going to focus on what the judge allegedly got wrong, but what she got right. There was a request to strike down the arbitration agreement, and the judge firmly said no. That is a fundamental understanding of how arbitration works and what you can and cannot do. But why did the award get struck down? It's not because there was inadequate legislation to guide the judges, but the loopholes, for example, misconduct loopholes that still remain in Nigerian law, was used in an effective manner to get an award annulled when possibly it shouldn't have been annulled. So if you look across most African jurisdictions, at least, even though, as Abba indicated, there is no solid data as to how many awards are being enforced through the courts, I would say it's the majority. Because if there were more awards that were not enforced, we would have the data to back this up, even though enforcement still remains a major concern to most people who are operating on the sub-Saharan continent. So overall, I would say that the African courts are more pro-arbitration than it first appears. You get the outliers, the aberrations, but there are aberrations in every system. If I go to France, I will find Pirelli. I will find the confusing cases in Dutco. I would find ETA versus Prime in England, judgments which sometimes are not satisfactory, and practitioners know they're not satisfactory, but they still remain on the books. And maybe the idea is that we don't focus on the aberrations, but look towards the cases that are actually going through without concern.
Thank you, Tunde. So I'm going to actually follow up on your invitation not to look at the aberrations, and to look at the positive side of things. But often, if you put yourself in the shoes of a foreign party and their outside counsel, one of the key concerns when they're looking at the prospects of enforcing an arbitral award in an African jurisdiction is lack of predictability, which can come from different things. There could be simply a lack of knowledge of the local law by foreign parties, and that's perfectly normal. It could be also that court decisions are sometimes a little bit inconsistent, and that's a problem that really can only be solved by the judiciary itself. But often the lack of predictability as to how the courts are going to handle a particular argument with respect to the enforcement of an award comes from the fact that there's perhaps not enough material, if you want, not enough decisions, not enough precedents, so that we don't know for sure exactly how the chips are going to land if you initiate your enforcement proceedings and the other side raises the arguments that you think they're going to raise. And so in that respect, I was wondering whether there was room for cross-fertilization across jurisdiction. Justice Patel, Abba, was telling us in passing about this case in which the courts in Zambia, if I remember correctly, referred to case law from Zimbabwe. And Sarah, of course, showed us the map of the model law jurisdictions in Africa. And so despite all of this diversity, I was wondering whether there was, according to the three of you, some room for local courts to routinely, at least in model law jurisdictions, routinely refer to the case law of other jurisdictions to basically alleviate this concern as to lack of predictability, lack of material precedents, etc., etc.? Or is that something that is just politically or culturally too difficult? So any of you?
Remy, first of all, I don't believe there's a lack of material. And for example, in Nigeria, there's a huge body of jurisprudence as to what arbitration is, what enforcement is, because that jurisprudence dates back to cases from, for example, 2001, there's Raspal cause versus FCDA in 2001, and they're older cases where you can find jurisprudence. I think what most foreign investors are reluctant to do is trust local counsel to guide them through. And that came out in the Attorney General's keynote speech the other day, that in certain jurisdictions there is some sort of a restriction. Yes, the markets are not as free and we don't work into each other's jurisdiction easily. But I know in East Africa, for example, because there's nobody from East Africa, they have a legal community which is quite linked, and they refer to each other's precedents quite a bit. And that's the East African economic community are quite interlinked in that way, and they refer to each other's precedents. The West is slightly more different. So again, this is why it's easier to say we can cross-fertilize. But if you look at Africa, West Africa, for example, it's a combination of common law civil countries, which are sort of split one after the other and are not linked in any way. But there is still reference, for example, in Nigerian jurisprudence to Ghanaian jurisprudence. Maybe not so much in arbitration, but there's definitely a cross-fertilization.
And just remind me, so Nigeria is definitely a model law country. Is Ghana also a...
Yes,
Ghana is also... Okay. No, so that would make sense. Okay.
I think the only ones might not be Sierra Leone and Liberia. But insofar as the common law countries in Africa litigate and arbitrate, I think there is that cross reference. I can't speak about Southern Africa, so I'll defer to the ladies to speak about Southern Africa.
And Sarah and Abba, do you have anything to add to Tunde? Otherwise, I think Bankole has got a question, I understand.
Sure. Thanks, Remy. I'll keep it brief, but the South African courts readily refer to foreign judgments. In the ordinary course, it is something that we do because we believe it's important. They're not precedent setting, but can be informative and useful. I believe that in our enforcement jurisprudence, there have been references made to foreign case law. We have a very strong body of domestic case law, though upholding enforcement. So I would say that the bulk of what the judges will refer to in South Africa would be local case law, but there's absolutely nothing stopping them, and I think they are certainly open to being persuaded by foreign case law. So I hope that answers your question.
Thank you. Professor Bankole, I think you have a question. If not, we're going to move to the first question from the audience. We have a question from Professor, please.
I'm on mute. Yes, sorry, I was trying to unmute. I'd like to hear from the various jurisdictions on how your courts deal with the issues of a challenge to an award that has the underlying agreement is tainted with fraud or illegality.
And so that's a very good question. I don't know who wants to take it first, and people from the audience should also feel free to intervene. But if I may ask a follow-up question, Professor, so the assumption, I guess, behind the question is that when an award or the arbitration agreement itself is tainted by fraud or illegality, we should potentially treat the enforcement slightly differently than we would treat enforcement in other circumstances. Is that correct? Is my understanding correct?
Yes, yes.
Thank you. So I don't know if Sarah, Tunde, or
Remy, can I come into that very quickly? We have had also instances in Zambia where that is actually one of the grounds under which an arbitration award can be challenged and is the subject of being set aside. It's of course not the court's place to jump into the arena, as I said, but the party alleging the fact that the award is tainted with illegality has to prove that. It's a very high burden of proof, and the courts in Zambia have taken the view that yes, certain awards have been set aside, but not that the court will jump into the award itself, because the courts are minded that their role is not to examine the merits of the award. But if it was so clear that the underlying arbitration agreement or the whole issue is not arbitrable, for example, I mean, that is one of the standard grounds for setting aside. So you cannot take a matter that is not arbitrable and then take it through the process because it's called arbitration and expect to get away with it. But of course, it depends on the activism of the parties, isn't it? How actively is that being challenged? And it will only come to the attention of the courts when somebody applies to set it aside. But just to say that the courts are now more and more minded that you don't just jump at the first citation of non-arbitrable or the fact that it's tainted with illegality. The party must do more than just cite that. Thank you.
Thank you. So we have a question from the audience. Emeka, if you would like to unmute your microphone and not only read your question, but tell us why you're asking the question, what you think the answer is. But perhaps before you do that, would you mind telling us in one sentence who you are by way of background so that we get to know you?
Okay, thank you so much, sir. My name is Emeka Nwadioke. I'm a lawyer practicing from Lagos, Nigeria. I'm actually an aspiring arbitrator. I plan to take the examination in December. So I was excited when this program came on. Going to the issue, I was wondering the long-awaited investment protocol to Abha. How can it probably assist in enforcement of arbitral awards? Because if we're able to get it right with that investment protocol, you may see a situation where you have a continent-wide framework instead of the disparate situations we have presently. Thank you so much.
Remy, we can't hear you.
I was saying you have unmuted your phone, so please, Tunde, go ahead if you wanted to say something.
Oh, no. I was just saying we couldn't hear you. With respect to the trade agreement and the framework, it would be a good idea if we could get a universal framework. It's what the AU has been working at for years. But the difficulty in that is that we are not sure how that agreement is even going to operate yet. Are we going to create a sort of exit style mechanism? Or are we going to adopt a sort of, how do I put this? I would say if it's not an ICSID mechanism, I would say we take a HOHADA style approach, because again, this is based on treaty, and this is a system that we already have. We already have the HOHADA, a sort of template that allows us to do that. I'm hoping we can have an integrated ICSID-like system, but those kind of systems are not without their own problems. If you are dealing with a homogeneous legal system, it might work. When you have complex legal systems at work, it becomes difficult to distill some sort of unitary code out of it. That is the problem of that unified system.
Thank you, Tunde. I think we've got another question from the audience, a question from Tracy. Tracy, if you would like, please, to unmute your phone and maybe summarize your question, again, telling us why you are asking the question, or what you think an answer might be. And before that, telling us very briefly where you come from, and a little bit more about yourself.
All right, thank you very much for this opportunity. And this is a very good program, I believe. My name is Tracy, like you rightly said. I'm a PhD student at the University of Salford, engaging something similar with the question that I'm about asking. So I'm asking, I know it's a known fact that, state courts actually tends to be more lenient towards states, like, foreign states, when issues of, enforcement of arbitral awards come before them. I mean, in the context of investment arbitration. So how different is the African court approach in this regard? I know state immunities practice the same way almost across board, but I do also know that there are some variations. So in your experience, do you think that when a case comes before the African court, they are likely to rule similar to what other jurisdictions have done, in terms of setting a set of states that are not attachable? I know a lot is actually changing now in regards to the matter, so just want some clarification on that.
So thank you, Tracy, for your question. I think by way of further introduction.
Hello?
Yes, can you hear me? So thank you for your question. And by way of further introduction, it's a question that the panelists and I had discussed very briefly when we were preparing for this panel 4. And simply because in many jurisdictions in Africa and elsewhere, the state is going to have such an important impact on the economy. The state will be the #1 economic actor. And so it's a question which, from a practical standpoint, often will arise. What is the attitude, generally speaking, of the courts when it comes to the enforcement of an arbitral award, where the respondent to the application for enforcement is a state-owned entity or the state itself? Do we have still some reluctance or some lack of independence on the part of some judges who find it difficult sometimes to make decisions that are going to go against the interests of the state? And it's not an African problem as far as I'm concerned. It's something that very much exists across Europe, but it's a real issue, I think, probably in Africa as well as in Europe. So you raised your question in the context of immunity specifically. I guess I can see how judges could use the tool of immunity to avoid having to make decisions against states and state-owned entities. But how do we deal with that? Is that a training question? Is that a cultural shift question? What's your perspective on this, panelists?
Perhaps I can start first, Remy, but I would absolutely be interested in Tunde and Abba's views on this question as well. From a South African perspective, I think I gave some interesting examples where our courts didn't shy away from enforcing against either foreign or South African owned entities. Generally, from an immunity perspective, the South African government is not immune from enforcement, except in relation to immovable property and property where the attachment would severely disrupt service delivery. So there are some exceptions. And I think we've seen the South African court be fairly robust in relation to applying exceptions to enforcement. I think, Remy, you may have been alluding to the public policy question and how state courts might apply that. And at least from a South African perspective, there has been a very limited application of the public policy exception to enforcement. Really, the only cases have been examples where enforcement was refused because of punitive damages awards, which aren't recognized in South Africa. And then not just the fact of the punitive damages not being recognized, it was the very extreme extent of the punitive damages that was found to be against public policy. So not really linked to state immunity in our jurisdiction. We have had instances where we've been acting for clients in other jurisdictions where enforcement in relation to state entities has been problematic. So I think there is, as we've stated numerous times, and as all my fellow panelists refer to, no one size fits all answer for Africa.
Remy, can I just come in to complement what Sarah has just said? You know, we all understand and we treat conferences like this and we try and deal with Africa as a whole. And I think we must accept that we can't paint it with one paintbrush and expect to have a uniform answer. In this particular panel, we're talking about African courts and the enforcement of awards. And as I said to you when I was presenting my topic is, I would like to see more conferences dedicate themselves and more sponsors to come forward on the very critical issue of training of judges. Now, I say this as a judge myself, but having come from a pro-arbitration background, and I'm more minded of the fact that it's very difficult to bring a judge on board and say, come now, we need to train you. Because it has to be done in a very sensitive manner. It has to be done in a politically correct manner. And I'd like us to say, let us be the voice of what we want to see. I mean, let us be the change that we want to see. We want to talk about arbitration. We want to talk about institutions in Africa succeeding. We want to talk about capacity building. We want to talk about African arbitrators coming on board. But let's also talk about the help and the sensitization that perhaps the judiciary needs. And maybe that is something we should also be looking at, is involving the judiciary in a standalone conference such as this to train them in high value, complex issues. And of course, a lot of those issues will relate to state entities. What is the judiciary going to do? What does it mean if the state, and I think Tunde said this earlier, we need to be careful. Do we have the right party to the arbitral proceedings? Just because there is a state entity doesn't necessarily mean it's the government itself that is in the arbitral proceedings. So my take on that is invest in capacity building. Let us see the courts that we want to see. Let us invest in those courts as well. And then we talk about how the courts are handling the issue of enforcement. I'll leave it at that. Thank you.
Thank you. And so I might have missed this, but I think one underlying point in what you're saying is it is difficult sometimes for local counsel to go and train the judges because judges can't quite be trained by people who are appearing before them. It's a bit difficult. So how do we deal with training? And is that something for institutions or not? I mean, we know that the Chartered Institute does a huge amount of training for practitioners and the branches are more or less strong depending on the jurisdiction in Africa, but what else can we do?
I think if I respond quickly to that and pick up from what Abba said, for example, I know that the ICC, for example, invite the OHADA court to come and sit on its court sessions where it approves awards, approves arbitrators. So they are they're desensitized effectively, and they understand what's happening. and they're not taking just a narrow view. And they're quite pleasantly surprised when they get to the court. When judges from other jurisdictions get to the court, they're quite surprised what happens there. I think the local institutions should at least invite the judiciary in to see their mechanics. Once the judiciary understand that arbitration is quite a very detailed affair. I think it was Charles Nairac who said it earlier, that the attitudes, even in France, saying, you guys are cowboys. And if people invite judges to see the process, i.e. the institutions say, look, this is how a process works from beginning to end, I think that would alleviate the problem. But secondly, I know personally that there's been quite a lot of training over the last decade of African judges. Every year, there is a retreat of Nigerian judges in somewhere, in some jurisdiction or the other. And the sole purpose of this retreat is to talk to them about arbitration. And they look forward to these retreats because they're very nice retreats as well. So the question is, Abba is smiling. Abba, I would say no more. The question is, are we getting through to them, or is there another reason where state entities are involved? And I think we have to separate this. I think the commercial cases are being enforced. I don't think they're delaying where there are two companies involved in an international arbitration, they bring it in front of the judges. I don't think there's a problem with those awards being enforced. I think the state entity and state awards, which sometimes flip over to the investment side, is these are the awards that are causing the issues, the perceptions to be created, in the sense that they're delayed, like IPCO and NNPC, and someone said it's going to be delayed. And now we have this $9 billion, $6 billion and interest. I don't like to call it $9 billion because it's not 9, it's 6 plus interest that is creating the $9 billion judgment. And I think it's the perception that states are using their courts to block international arbitrations, that we have to differentiate from the effective workings of the local courts in commercial matters. Those are two distinct things we must separate.
Thanks, Tunde. Sarah, I'm conscious of the fact that we have run out of time, not quite officially. Sarah, do you have a final thought on all this?
Thanks, Remy. I think it's been a fantastic debate, and I thank you and my fellow panelists, Tunde and Abba. It's been excellent to get your perspectives on it. I think the message that certainly is coming through is that there is no unified answer in relation to Africa, but there are some examples of good enforcement track records, and some jurisdictions that need some training and need some input, possibly from the arbitration community on nice retreats and possibly from the institutions. But I think really it may all boil down to willingness among the states themselves. It's a political will question. We've seen in South Africa the adoption of new legislation, and I think that's really driven a lot of interest in the direction of arbitration, and along with it, a desire to make sure that we're doing the right thing in relation to enforcement. Thank you very much, Remy. Thank you everybody for listening, and thank you to the organizers for having me.
Thank you, Sarah. Thank you, Tunde and Abba. It's been a pleasure to chair this panel. We have run out of time, so we'll leave it at that. I'm conscious that some of you have other commitments. Thank you to the organizers for this really exciting inaugural Africa Arbitration Day. Look forward to the next editions. Thank you.
Thank you, Remy. Thank you.
Thank you, Remy. Thank you, everyone.
Thank you, Remy. Thank you to Abba, to Sarah, and to Tunde. There was a very interesting question from one of the leading lights of the Nigerian judiciary, but because of time, we will not be able to take it, but perhaps privately, he wanted Tunde to answer the question. This program has been very remarkable. When we started yesterday morning, our keynote speaker, the Honorable Attorney General of the Federation of Nigeria, had an award of over $9 billion hanging on his head. And with some trepidation, he still spoke with us without clarity as to whether the London courts will give an extension of time in the P&ID arbitral award. However, he admitted that Nigeria needed to improve her in-house keeping and due process in negotiation and drafting of agreements and treaties that have arbitration clauses and provisions in order to avoid the problem that led to that award. Later on yesterday, I understand that the London court granted Nigeria an extension of time to challenge the award. So I think it was a good day that we are doing this on Africa. Today's keynote speaker, Justice Chibita of the Supreme Court of Uganda, highlighted that there's a dearth of statistics. And without data, we cannot know if and when we make gains. And that's why some of the issues discussed today, the questions raised and so on, we need to keep them on the radar so that we would know if there has any improvement in the arbitration space. Justice Chibita affirmed that Uganda recognized the arbitration of tax issues and cited a case which arose between the national, within an international oil company in Uganda and the Ugandan tax authorities. This contrasts with Nigeria, where the Court of Appeal has held that taxation is not arbitrable. And so it shows that in Africa, there are very interesting perspectives, and we need to review and learn from each other, particularly because decisions can be persuasive. Maybe the laws maybe need to be aligned. Today's panelists have shown that in most parts of Africa, there are reliable laws, institutions, good arbitrators, counsel, and systems to support investment and commercial arbitration. And there is an encouraging positive track. The OHADA system operated in French-speaking African countries in Africa not only offers arbitration center, but also support for enforcement. And this makes it unique because they issue a certificate of enforcement. So on behalf of the British Institute of International Comparative Law, Bankole, School of International Arbitration, Queen Mary University of London, and of course my very own Babcock University. We want to thank our keynote speaker for today, Justice Mike Chibita of the Supreme Court of Uganda, the moderators, Charles Narak and Dr. Remy Gerbay, our sponsors, Linklaters and Freshfields, and of course our most distinguished panelists who work tirelessly to present complex issues in a short but easily understood manner. Once again, our objective has been to ignite a series of engagements, and this being the beginning in the arbitration space in Africa. And we hope to support and assist governments, government entities, and private organizations in capacity building, review, negotiation, drafting, treaties, rules, regulations, so that the enforcement and use of arbitration in Africa will continue to rise. So we would like to conduct studies to review cases and show that it may not be very good, but it is not bad, and there are good chances. And so we are open to working with you and to pushing the frontiers of arbitration in Africa. We look forward to having you next year and hearing suggestions from you and to collaborating with you. Right now, I'd like to hand over to Professor Yarekwivel of Bankole for his final words. Thank you.
I think the main person who needs to be thanked today is you, Bankole, because it was your idea to put together this event. And if we were in the normal circumstances, then I'm sure you would hear a very loud round of applause now. But this is our first event, not the last event. And we are open to your ideas. Training was discussed. Bankole, by the way, does provide virtual training at the moment on different topics, from public international law more generally to the law of the sea. And there is also my course on investor-state dispute settlement, which is fully online, and you can take it at any time. But yes, we're open to your ideas, and we're also interested to hear your feedback about this particular conference, whether you thought that the format was good, whether we missed any topics, whether we should do it differently next time. We had around 100 people over the last 2 days attending this conference from very different jurisdictions with very different laws and approaches to arbitration. And I hope it was a good opportunity for us to learn, to meet each other virtually, hopefully in person next year. And I would like also to thank the speakers, the moderators, the sponsors, and I hope to see you in a year or around the time. Thank you very much. That concludes our conference, and please stay in touch, follow us on social networks, and we'll